Thank you, everyone, and thank you, judges. Thank you, bailiff. Please be seated. Be seated. Welcome, everyone, to the final round of the Price Media Law Moot Court competition. Congratulations again to the finalist teams. This is a very exciting moment, and we're looking forward to hearing your arguments. It gives me immense pleasure to announce to you all the final bench of the competition. You have all been looking at their profiles across the past week. And at this competition, as you know, we like to do things a little bit differently. So instead of me reading out their bios to all of you, we have a small segment just before we start the finals where we actually would like to make media law and international human rights law careers more accessible to you all, because as you know, this is a big part of the mooting community. It's also something that the founder of the competition, Monroe Price, held very dear to his heart. And as you were all part of the memoriam, you heard him talk about the importance of making media law and international human rights law, freedom of expression, etc., more accessible. And so I would like to invite the various judges that we have in the final bench to introduce themselves to you all, tell you a little bit about their career, and give you a little bit of advice about what you can and should do should you wish to follow in their footsteps. And to do that, I would like to invite the judge president of the final bench in today's round, Justice Leona Turan, Judge of the Constitutional Court of South Africa, to begin by saying a few words. Please proceed, Judge. Apologies, we can't, I don't think the microphone is working, Advet.
Yes, good morning. Thank you, Sanya. Good morning. And I think I address the finalists first to say you are going to perform much better today if you relax. And if you just want to look at one smiling face, you can look at my face. So try not to be intimidated by the bench. It's a great honor for the two teams to be in the finals. So try to enjoy the moment. And a motto that I've tried to always live by is to be the best I can be. So today, try not to win the moot. Try to be the best that you can be. Deliver your best arguments. Answer the questions to your best ability. And I'm going to say something that might sound very basic, but listen to the questions that are posed by the judges. Listen to the full question before you answer, and try to answer the question and relax. If you need time to think, just pour yourself a bit of water. And all the best. Thank you.
Thank you very much for those words, Judge Turan. I would like to now invite Lord Justice Warby, the Judge of the Court of Appeal of England and Wales, to please say a few words.
Well, I think I'm going to be the grumpy-looking one on this bench. People tell me that I do look a bit grumpy when I'm listening hard. It's only because I find it hard to think sometimes. So don't, if you get a grumpy look from me, take it in any bad way. You've all done extremely well so far, and I'm sure you'll do very well today. We've been invited to give you a bit of a steer on how to become a media lawyer. I don't have any very good advice because I started out studying English, French, and Russian at school and wondering what on earth to do with my life. Tumbled into the law by mistake because I thought it was a good thing based on my reading of French literature, in which the heroes always seemed to get on very well and do very little work if they read law. And then became a media lawyer by accident. So I think probably the lesson that I would give you is that it's not necessary, and it's probably not particularly useful to strive with your every fibre to become a human rights lawyer and nothing else. It's probably good to have a wider experience of life and the law as well, however much you put into that. And let's hope you get lucky.
Thank you very much, Judge. I would like to now invite Judge Arthur Kusch, from a judge at the European Court of Human Rights, to please say a few words as well.
So, can you hear me? Okay, all right,
Yeah,
it seems working. So also welcome everybody, especially finalists. So first thing, I would like to also congratulate finalists for being here, but I actually want to congratulate everybody because being here, I think you have, despite I think some of the teams had, and I know that because I was coming with my team also until COVID, and it's nice to come back to Price community, and that because you probably didn't made it up to finals, but you were first of all best in your country. You were best in regional rounds, and so you made it up to here, and you have to appreciate that. And that's a lot of things, and that's good to acknowledge that. And so not everybody made it here. And about advice, it's also how to say, it's probably as I'm now in the European Court of Human Rights. I was a judge before in Constitutional Court. But one thing I can say, for me, it was already, after graduating university, I know that I want to go in the human rights field and I want to study human rights. And after doing a master's, it's not immediately that you get to top-level positions, as sometimes people think. It might take time. It might take sometimes endurance, and sometimes, because after graduating master's, I was also in a year, I was without a job. I was thinking whether to switch to competition law, commercial law. You have many offers, but I was thinking, I did human rights master, and was it the reason I did it to continue with commercial law? So I stick to that. So the opportunity came as a university to start a university, and then later I went to courts. So if you know what you want and you stick to that, the chance will come. It may take time, but if you follow that, it will come. And then just I wish you all the best. And if with your future career, with your future dreams, and the best thing, if you know that you want it, just go with it, and it will happen.
Thank you, Judge Kush.
Welcome.
I would like to now invite Dr. Mariam Kamel, a barrister practicing in media and information law at Matrix Chambers, to please say a few words.
Thank you. Good morning, everyone. Congratulations to all of you. I'm very early career. I'm in my first few years of practice, and I very much stumbled my way into developing an interest in media law. I did a research degree, which was on the right to privacy, and that's when I looked at comparative aspects of this area of law. I didn't think I'd make a career out of it, but that's predominantly my area of practice now. If I had to give one piece of advice, I would probably say that do not self-exclude yourself. I think that sometimes, especially early on in our career, we think that we need to fit a particular mold, and that's what opens doors. But in my experience, that's often a misconception. Being yourself usually will not and should not exclude you from other opportunities if you are otherwise well suited for it. So do not self-exclude yourself is my piece of advice.
Thank you very much. And of course, Professor Rachel Murray, who is the director of the Bonavero Institute of Human Rights, we would love to hear from you as well.
Thank you. Good morning, everyone, and huge congratulations to the finalists and to everybody else for getting here. So my career, I guess, in human rights, when I started this, there was no such thing as human rights. It wasn't a term that was mentioned in the UK. It was civil liberties, and the idea that you'd have a career in it was unheard of. And so I did a PhD looking at the African human rights system under the supervision of Professor Addo, who is there in the audience, and then remained in universities because it was a very useful vehicle to do a combination of research but also practice. So litigation before UN bodies, before the African human rights bodies, working with governments and civil society and others. And then newly arrived here, which is an absolute privilege and honour. If I had advice for you, I would say follow your passion. There are a whole variety of different careers in human rights, and it's not linear. So you have to be a little bit creative and entrepreneurial, but don't be afraid to follow your interest, and huge luck to you all. Thank you.
Thank you very much. I'm looking at the audience We've got 5 minutes if there's any burning questions you want to ask our final bench judges about their lives, about their careers, about the work that they do. And I'm looking now again at the final bench judges if there's anything that you've left unsaid that you'd like to add. All right. So I see that there are no questions, unless I've missed anyone's hand. Oh, I see, there is a hand.
Is it important to win the argument or to have peace?
Judges? Who would like to take that one?
Yes. I suppose in the courtroom, it's important to win the argument. In the world, it's important to have peace.
Thank you, Judge. Well said. On that note, I know that the finalist teams are eagerly waiting to present their arguments. I'm looking at the bailiff. Are you ready? And I'm looking at the final bench judges. If we're all ready, then we can begin the final round. And I will hand over to the judge president to begin the proceedings. Thank you all very much and good luck.
Thank you. I will now invite the bailiff to open the session.
All rise. The Universal Freedom of Expression Court is now in session. Honorable Judges, Professor Rachel Murray, Lord Justice Warby, Judge Arthur Cush, and Dr. Mariam Camille, presiding with Judge Justice Leona Ferron as President of the Board. The current matter before this court is the case between Dr. Reyes Victoria and Graviola Taquera as applicants against the State of UC as respondent. Each side has 45 minutes to present their case, and first counsel of the applicant is requested to come forward.
Yes, good morning, counsel. You may proceed.
Madam President, Your Excellencies, it is an honor to plead before you today. May it please the court. I am Marco Giorgiani Dava, and together with my co-counsel, Gian Aloro, and of counsel Zaini Zaragoza, we represent the applicants Graviola and Vittoria. I will speak for 21 minutes on why UCSI's acts of monitoring Graviola's communications violate her rights under Article 17 of the ICCPR, and why the act of blocking access to her website violates her rights of freedom of expression under Article 19 of the ICCPR. My co-counsel will discuss for 22 minutes regarding the same violations of the ICCPR, but pertaining to the rights of Dr. Vittoria. We respectfully reserve 2 minutes for rebuttal. If there are no preliminary observations, I shall now proceed. Your Excellencies, this case concerns a journalist who, in the exercise of her journalistic functions, was unlawfully monitored by the respondent state, and whose website was obstructed to prevent her from publishing the truth about UCSI's unlawful activities. A harsh reality that our client, Graviola, had to face, and an even harsher reality.
Mr. Dava, is it common cause that there was surveillance, or was there a suspicion of surveillance?
Madam President, the applicants allege that there is a suspicion of surveillance, and that is sufficient before this court, Your Excellencies. Because as held, for example, in the European Court of Human Rights cases of Klaas and Germany, as well as in Jabo and Vichy and Hungary, both of which concerned the unlawful surveillance of the state on telephone communications, mere existence of laws which allow for surveillance suffice and give rise to a threat of surveillance. Here, Your Excellencies, the applicants make 2 points for the first issue. First, the respondent violated Graviola's right to privacy under Article 17, and second, the respondent violated Graviola's freedom of expression under Article 19 of the ICCPR. Now, with regard to Article 17 of the ICCPR, Your Excellencies, we recognize that every individual is protected from unlawful and arbitrary interference to the right to privacy. And in determining whether an interference is unlawful and arbitrary, we look into the 3-part test recognized and established by human rights tribunals such as the African Court on Human and People's Rights, the European Court of Human Rights, and the Inter-American Court of Human Rights. Simply put, any interference must first be provided by law, second, pursue a legitimate aim, and third, be necessary and proportionate.
But, sorry, counsel, but before you proceed with the test, could you guide us to the facts of the case and actually that indeed it was, when we talk about Graviola, not Vittoria, that her communication was basically surveilled. Could you guide a specific paragraph of the facts of the case forward?
Certainly, Your Excellency. In paragraphs 21, 31, and 32 of the facts, these facts, Your Excellencies, contain that there are allegations of monitoring journalists' communications. And this is why, Your Excellencies, we submit before this court that even if these are mere allegations, it gives rise to a cause of action for Graviola to question the validity of the respondent state's monitoring. This is because, Your Excellencies, and pursuant to these oral proceedings, we submit that the first and third limbs of the three-part test were violated. First, with regard to the provided by law test, we note that the respondents in their written pleadings in paragraph 6, page 20, state that foreseeability needs sufficient precision. And to this, Your Excellencies, we submit that the law that they rely on, or the UXI National Security Act, is not sufficiently precise. If I may, Your Excellencies, in paragraph 12 of the facts, Article 1 of the UXI National Security Act uses vague and overbroad language. For example, we do not know what a threat to national security is, and we also do not know what is damaging to UXI's interests. Now, we also note, Your Excellencies, that absolute precision is not required in a law or domestic legislation, but the reason as to why there has to be a sufficiently precise definition or a criteria for assessing a threat to national security is in order for us to avoid affording unbridled discretion to state authorities to, for example, in this case, monitor anyone's communications. If we rely on UXI's law as it is now, then that is precisely what we will be doing. We will allow the UIA to intercept any individual's communications in the guise of protecting national security. Moreover, Your Excellencies, when it comes to the foreseeability of a law, we submit that such domestic legislation should also have adequate safeguards against arbitrary application. However, in this particular case, the respondent state cannot rely on Article 80 of the UNSA, which provides that any person who feels aggrieved that their rights have indeed been violated by the respondent state, they may raise that or elevate that matter to the independent judicial body. But in this particular case, there is no way for an applicant or a subject of interest to know that he or she indeed is a subject of interest. Because as recognized in the case of Malone and United Kingdom by the European Court of Human Rights, the very essence of covert surveillance measures is that they remain a secret in order to maintain its effectivity.
Yes. Mr. Dava, why is Article 80 of UNSA not of use in this matter, where it says the Intelligence and National Security Tribunal has competence to hear any claims and disputes lodged by persons aggrieved?
Madam President, we do not question that the INST in this particular case may indeed have judicial review or such power over violations of the same. However, it is our submission that the applicants are not able to effectively avail of this remedy because for them to know that their rights have been aggrieved in the first place, they should know that they are a subject of interest and that they are being monitored by the respondent state.
Article 10 provides for the tribunal to oversee warrants for equipment interference. Is that not a safeguard of some value?
While we do agree, Your Excellency, that Article 10 does provide for the authorization of a warrant by the INST before any interception may be made, it is our submission, however, that the presence of an adequate safeguard does not cure the defect in order to satisfy the provided by law test.
Can I just take you back to the point you made about absolute precision not being required? Can you say more about that and some of the case law that you would rely on?
Certainly, Your Excellency. We note that the terms threat to national security are indeed vague and overbroad in this particular case. Because if we rely, for example, on the case of Zakharov and Russia, where it concerned Russian law which permitted the installation of equipment interference. The European Court of Human Rights deemed the terms military, economic, national security to be vague. And in the earlier cited case of Jabo and Visi and Hungary, the terms intelligence necessary for national security were likewise deemed to be vague and overbroad. This is why, Your Excellencies, we submit that there should be a definite criteria or at least an objective standard put in the UCSI's provisions of the UNSA in order for the law to be considered sufficiently precise.
What would you suggest would be an appropriate objective criteria?
Madam President, we note, for example, that UCSI could have, for example, provided more specific criteria for threats to national security, such as including words like acts which constitute armed attacks or violence, or even espionage in that case. However, in this particular case, the mere reliance on the terms threat to national security would not suffice. In the alternative, however, that this court deems that UNSA is sufficiently precise, and therefore the act of monitoring by the respondent state is provided for by law, then we move to the more contentious point, which is that the monitoring done by the respondent state was neither necessary nor proportionate.
But
Now,
what was the monitoring? What was the monitoring? I mean, you've relied on the very existence of the law as amounting to interference, as a way of getting round the fact that the Constitutional Court said there wasn't any evidence of actual monitoring. I'm not really understanding how you can say there was actual monitoring.
Yes, Your Excellency. In paragraph 19 of the facts, Your Excellencies, it can be seen that Dr. Vittoria, when she went to the airport, was detained and her devices were searched. And because of that search, Your Excellencies, her laptop was retained. And because of that retention, Graviola's communications with Dr. Vittoria were discovered, and because of that discovery, it was continuously monitored until the point that UCSI discovered about the publication of the expose.
Well, it's the last point that you haven't really addressed. You say that because of the discovery, there was continuous monitoring. How does that follow? They look at the computer, they see what's on it. Doesn't necessarily follow that they monitor everything that happens after that.
Yes, Your Excellency. This leads the Council to the discussion on why it was not necessary and proportionate to monitor Graviola's communications to begin with. And because when we talk about necessity, Your Excellency, there has to be a pressing social need relied upon by the respondent state in conducting such act of monitoring Graviola's communications. And a pressing social need is premised on the existence of a direct and imminent threat. Here, however, we note that the respondents as well, in their written pleadings in paragraph 12, page 23, states that the pressing social need here is shown in the existence of the Kamapu drug cartels expanding within UCSI. However, Your Excellencies, the contemplated pressing social need under the test of necessity must rise to the level of a direct and imminent threat, such as existential threats like terrorism, armed attacks, or violence. If we can look at paragraphs 6 to 8 of the facts, the last instance of drug-related seizure, or any drug activity in UCSI for that matter, happened way back in 2023. Now, this is why the applicants are not contending the legitimate aim being protected, because when the respondent state enacted the UNSA in 2024, it was as a response to the 2023 seizure. However, the monitoring and blocking here happened in 2026. From the timeline between 2023 and 2026, Your Excellencies, no other drug-related activity occurred, and as such, there was no pressing social need to monitor Graviola's communications. Additionally,
can I stop you here also? You mentioned paragraph 19, but it was Dr. Vittoria's computer which was searched, and also the content. It was not Graviola. They found out that there was a communication with Graviola. So do you argue that any person with whom Dr. Vittoria had a communication can claim a constant monitoring after this, or Graviola has any other arguments?
That, Your Excellency, is what the applicant is submitting would be a dangerous precedent that will be set if we allow the monitoring of Dr. Vittoria's communications to be a door to intercept communications that Vittoria had with any other individual. Because imagine, Your Excellencies, the online intrusion on our spaces where we reasonably have an expectation of privacy. We note, Your Excellencies, that in paragraph 24 of the facts, it does state that any interception done by the respondent state was made with a judicial warrant. However, we contest this, Your Excellencies, because in Article 10, the warrant is only issued for equipment interference, And that means there was indeed, probably, a warrant for Dr. Vittoria. But at the point in which UXI monitored Graviola's communications continuously to the point that they discovered about the publication of the expose, that is a violation because Graviola never found out that she was being monitored anyway. Now, Your Excellency.
Mr. Dava, just please, to get back to your argument that the measures lack clarity and precision, is it not so that a statute related to national security and the collection of intelligence, in such a statute, the state should retain a margin of discretion and not for the very purposes of security and national interest, and not have to disclose all of its measures? Because if it discloses all of its measures, then it defeats the purpose of the legislation.
Yes, Madam President, we agree with the latter half of your concern, Your Excellency, that states are indeed afforded certain levels of flexibility with regard to interpreting what is a threat to their national security. But if I may, Your Excellencies, if Madam President was referring to a margin of appreciation to be afforded to the respondent state, we note that they cannot rely on the same because it has only been established and recognized in a single jurisdiction, and that is the European Court of Human Rights. Now, we note, Your Excellencies, that Graviola here was never a member of the Kamapu drug cartels, and her communications were never in line or in furtherance of the Kamapu drug cartel activities. And as such, there is no nexus between the monitoring of her communications and the alleged threat to national security. Your Excellencies, even if there was a pressing social need, however, we note that the monitoring was disproportionate to the protection of the national security of UXI. And this is because, Your Excellencies, in cases by the European Court of Human Rights, such as Sanoma Witgevers and the Netherlands, as well as even in the Constitutional Court of Africa case of Ama Bungane and the Minister of Justice, which we note, Madam President, was a member of the panel, adequate safeguards, or a least intrusive means, rather, would be indicated in the forms of judicial authorization, judicial oversight, or even the existence of other alternatives. Here, Your Excellencies, first, with regard to judicial authorization and oversight, Article 10 of the UNSA notes that any interception shall be made with a warrant. However, the same was not obtained by the police authorities for Graviola's communications. And second, we note, Your Excellencies, that other alternatives could have been exercised by the respondent state.
What are these other alternatives, Mr. Dava?
Madam President, we have two alternatives. First, there should have been no monitoring at all because Graviola was not in furtherance of any criminal activity.
That's not an alternative.
Yes, Madam President. The second alternative would then be, as earlier cited in the case of the Constitutional Court of South Africa, would have been a post-surveillance notification. In the earlier cited case, Your Excellencies, and I quote the majority decision, it stated that the court understands that pre-surveillance notification would defeat the purpose of surveillance. But post-surveillance notification is a way for the aggrieved or the claimant to question the validity of the surveillance to begin with. That is something that the respondent state did not exercise here, and we submit should have been available. As such, Your Excellencies.
Now, when we speak of national interest and national threat, sometimes it's too broad. We can just break it down because here the state wanted to detect illicit drug activities. And was the means they introduced not necessary or proportionate to the aims that they wanted to achieve? What do you say about that, Mr. Dava?
It was not, Madam President. And I note, Your Excellencies, that in this discussion of necessity and proportionality, we may also look into the need for the respondent state to block the expose to begin with, which is a byproduct of the monitoring. We note, Your Excellencies, that in assessing the pressing social need when it comes to freedom of expression, we look into the content, context, and intent upon which the publication was made. Here, however, Graviola's expose merely included interviews with individuals who feared that their rights to privacy were being infringed upon. And in fact, Your Excellencies, the language of the expose does not incite imminent lawless danger.
Sorry, if I may, does your framework require the state to take the risk of the harm materializing before acting?
No, Your Excellency. We do note that the state cannot or is not obliged to wait for the situation to escalate before taking preemptive action. But the test of necessity, Your Excellencies, requires a nexus which is shown in the direct imminent threat between the respondent's restriction and the alleged threat to national security shown in the acts of the applicant. That is absent in this case, Your Excellencies, precisely because the publication of the expose of Graviola here should be read in the context of vigilance in light of the unlawful monitoring done by the respondent state. Now, we note that the respondents in the written pleadings in paragraph 28, pages 31 to 32, questioned the truthfulness of the allegations in the publication of the expose. However, we cite the European Court of Human Rights case of Bladet, Tromsø, and Norway, as well as Jerseld and Denmark, both of which, Your Excellencies, concerned journalist activities, which stated, Your Excellencies, that journalists are presumed to have acted in good faith and are not required to conduct independent verifications of claims individually. Moreover, Your Excellencies, it would have been absurd for Graviola to verify such information with UXI, because in cases of national security concerns, it is the state which holds the entirety of the evidence. What incentive, therefore, does UXI have to present this evidence if it comes to the extent of them being exposed? Moreover, Your Excellencies, we note that even if there was a pressing social need to block Graviola's expose, it was never the proportionate action that the respondent state could have taken. And this is precisely because it was indiscriminate and wholesale. And this is frowned upon under international law as a prior restraint established in the cases of Yildirim and Turkey about Google sites, OO Flavos and Russia, as well as in Kharitonov and Russia, and even in the most recent 2023 case, Your Excellencies, of the ECOWAS Court of Justice, Asutik and Senegal.
Mr. Dallas, I remind you, you now have about 2 minutes left. You may wish to wrap up.
Yes, Madam President. As we are already in the test of proportionality, I shall just go to discussing as to why there could have been other alternatives that the respondent state could have exercised. And these are precisely 3 things, Your Excellency. First, they could have issued a court warning or an order or an email notification to Graviola about the consequences of publishing. We note, Your Excellencies, that in paragraphs 22 to 23, it was in November 29 when the respondent state filed an injunction, November 30 when it was granted, and December 1 when the expose was published. This means that the respondent state had 2 entire days to file an injunction. Why not use those 2 days to inform Graviola? Second, Your Excellencies, we note that they could have anonymized details within the expose or requested for the anonymity of the expose, Your Excellencies, which is considered as having been established in the 2023 case of Herbane and Belgium regarding newspapers' anonymity. And lastly, Your Excellencies, given the rich nature of UXI as a state and the massive technological infrastructure as shown in paragraph 1 of the facts, they could have exercised specific URL blocking. In Cengiz and Turkey, Your Excellencies, the European Court of Human Rights ruled that for more developed countries, it could be materially infeasible given the layers of encryption, firewalls, and extensions that are needed to be removed. Your Excellencies, the indiscriminate blocking of the expose here rendered inaccessible not only the alleged threat to national security, but all other legitimate and lawful information that Graviola published before. This causes a chilling effect, and we cannot tolerate this under the eyes of international law. The core of press freedom is to ensure that journalists like Graviola are able to keep governments like UXI in check, without which we will have failed in the protection of our rights and the protection of those who expose infringements upon them.
I don't see how it's the function of journalists to keep governments in check. Can you elaborate on that role, please?
Yes, Madam President, if I may just answer the question. Madam President, as recognized in multiplicity of cases, such as in Peterson in Denmark and even Stahl in Switzerland, journalists take on the role of a public watchdog who act as a checks and balance against government accountability and corruption. Your Excellencies, thank you. May it please the Court.
Thank you very much, Mr. Dalba, for your presentation. Your co-counsel may now come forward. Counsel, you may place yourself on record.
Madam President, Your Excellencies, may it please the Court. As introduced earlier, my name is Gian Aloro, the second counsel for the applicants. For the next 22 minutes, I will be speaking on how UCSI's imposition of sanctions on Dr. Victoria violated her rights under Articles 17 and 19 of the ICCPR. Your Excellencies, this second issue concerns how a state responds to expressions that criticize state technology. Dr. Victoria is an academic whose main advocacy was to make complex technologies understandable to ordinary people. However, for merely expressing concerns about state technology, she was dismissed from her employment, stripped of her residency, and her digital communications were surveilled.
I'm sorry to interrupt you, but I'm not sure it's accurate from the facts to say she was dismissed from her employment. Are you talking about the university?
That is correct, Your
I'm
Excellency.
sorry, thanks.
Your Excellency, we submit that when UCSI imposed these sanctions, they violated Dr. Victoria's rights to freedom of expression under Article 19 and her right to privacy under Article 17 of the ICCPR. And I will discuss each violation in turn. First, the termination of Dr. Victoria's employment contract violated her right to freedom of expression under Article 19. At the outset, it must be emphasized that any punitive measure designed to silence one's criticism against state technology or any state policy is already incompatible with the ICCPR's protective mandate. And while we do
Can you go so far as to say it was designed to silence her, or was it designed to protect a national interest of the government, and that was to control illicit drug cartels?
Your Excellency, while we do recognize that the respondents may argue that it was designed as to pursue a legitimate aim of protecting national security, we submit that this is not the case because Dr. Victoria was terminated because of the discovery that she was behind the @Fight for Victoria account. And I shall establish later on that these termination as well as the rescission and the monitoring of her digital devices violated Articles 19 and 17, specifically because they failed to satisfy the first and third limbs of the tripartite test. With regard to the first limb of the tripartite test.
But before you proceed, I also want to be clear about facts, if I may, about dismissal. So the national courts basically relied also on the autonomy of the university. And if we look at the facts of the case, actually, what the rector of the university did, I mean, we see that he decided first to suspend her and then only terminate agreement after he found out that she was behind the post, basically behind the, who basically had this Fight for Victoria afterwards, that she was behind it and that she was advocating daily protests in the campus. There were students who were not allowed to enter the university. There were students who were throwing stones. So there were disruptions. So tell me why university cannot do it, because I would expect that every employer might have an issue with such an employee. If you have an issue, basically, it's about the loyalty to your company. It's about basically observing rules, why we should approach differently Victoria. Do you have any arguments how we should approach differently in this case?
Your Excellency, while we do recognize the authority of universities to act on employment decisions, when such decisions are made in response to one's freedom of expression, the protective mandates of the covenant will necessarily apply, which will require the state to prove that there is first a pressing social need and that their sanctions actually meet the test of proportionality. And for this, I shall discuss the proportionality as well as the necessity of the sanction of termination, Your Excellency.
Your first issue is the legality of what happened.
That is correct, Your Excellency.
And my colleague's question went at least primarily to that issue. I think you were telling us earlier that you were challenging the legality of the measures. Are you pressing that point, or are you going to focus on proportionality instead?
Your Excellency, with regard to your question, I shall first address the test of legality, and I shall transition towards the question of Judge Cook's with regard to the necessity of the sanction. Now, as my co-counsel has earlier established, the test of legality was not satisfied, precisely because there was no sufficient definition with regard to what threat to national security really is. And therefore, this provided unfettered discretion to those charged with their execution, which is the UIA. Your Excellencies, if I may direct this court's attention to paragraph 12 of the record. Article 1 of the UNSA failed to establish clear, objective criteria as to what really constitutes as damage sufficient to trigger the application of the law. And therefore, the reliance of the UNSA on such objective standards would allow the UIA to rely on their own sole determination as to whether there really was a violation of the UNSA. And this is incompatible with the Human Rights Committee's General Comment 34 on freedom of expression, which requires laws to provide sufficient guidance to those charged with their execution to enable them to ascertain what sorts of expressions may be properly restricted and what sorts are not. And the law, such as the UNSA, which relies on subjective standards, already provide the police with the power to tag just about anyone as a subject of interest. Therefore, any sanction provided under Article 50 of the UNSA would have been deemed as not provided by a valid law. However,
Ms. Alora, what would your suggestion be as to how that law could be reframed not to give officials an unfettered discretion?
Your Excellency, for this we may take guidance on the European Court of Human Rights case of Weber and Saravia in Germany, in which the court only accepted legality because the law limited the harm to serious threats to national security and included terrorism and armed attack as an exhaustive list. However, this level of precision, which provides the severity of the damage as well as an exhaustive list of the prohibited acts, is absent in the UNSA. However, even if the court were to find that the sanctions imposed were in accordance with the valid law, it would still fail the third limb of the tripartite test, in which we submit that the test of necessity was not met. As my co-counsel has earlier established, to satisfy the test of necessity, the interference must meet two requirements. It must correspond to a pressing social need, and it must be proportionate to the legitimate aims being pursued. For this, I shall discuss each sanction in turn. With regard to the termination of Dr. Vittoria's employment contract, we submit that it does not correspond to a pressing social need. The Human Rights Committee's General Comment 34 provides that we must look at whether the individual's expression arises to the level of a direct and imminent threat. And if I may direct this court to paragraph 29 of the record, and if your excellencies are with me, we can find that the respondent state sanctioned Dr. Vittoria on the mere discovery that she was behind the @Fight for Vittoria account, further concluding that her speech was a threat to national security and public order. However, your excellencies, Dr. Vittoria's or the @Fight for Vittoria's posts merely advocated for the regulation and banning of facial recognition technology. If we may look at paragraph 26 of the record, on February 2, the account posted the symbol from Dr. Vittoria's Stop Big Brother campaign, as well as a video of her talk during the Conference on New Technologies. While in paragraph 27, on February 20, the account @Fight for Vittoria called for daily protests on campus in support of Dr. Vittoria, as well as a ban for facial recognition technology. Your Excellencies, nothing in the facts would establish that the post of Dr. Vittoria, as well as her expression, would incite a direct and imminent threat. And even...
What about break the camera hashtag?
Your Excellency, we do recognize that the break the camera hashtag may have vulgar themes. However, the use of vulgar phrases in itself is not decisive in establishing whether it is indeed a direct and imminent threat, as it may well serve merely stylistic purposes. And this has been established in the case of Terentchev in Russia, as well as of Gül and others in Turkey, in which the applicants also published a blog with an even harsher language, such as burning all cop infidels. And the court has ruled that even shocking, disturbing comments may still be within the protection of freedom of expression. Therefore, the impugned statements must be assessed in light with the context in which they were made. And it is noteworthy to establish that the protesters posted these comments in the context of mass surveillance in Yuxi, and the break the camera language is merely a display of metaphor to express their disagreement on being monitored. Your Excellencies, we also note that the respondents have argued in their written pleadings on paragraph 74 that the termination was necessary as due to her status as a trusted academic in NUU and her position as a senior advisor. But it must be noted that Dr. Victoria was using an anonymous account. And the Human Rights Journal Comment 34 provides that protection also extends to anonymous accounts because these very individuals may fear being persecuted or may fear retaliation from their public institutions, which is exactly what happened to Dr. Victoria when in paragraph 29, the NUU has found out that she was behind the @Fight for Victoria account. And Your Excellencies, I know...
Ms. Saloro, if we leave aside, let's look at the legitimate aim of the government. Would the applicants concede the legitimacy of the actions and of the legislation, that the legitimate aim was to curb illicit drug cartels?
Your Excellency, the applicants may concede with regard to the law in which the UNSA, in which was the basis as to the applications of the sanctions provided herein. However, it is the actual application of these laws and the interpretation as to whether there is indeed a violation of such law and as to whether it was actually necessary and proportionate with regard to the risks established in the facts. And it is our submission that it was not. And while we do note that there have been protests in the university, we submit that a direct and imminent threat must be of a nature that is critical to the functioning of society. And
it seems that Dr. Victoria, in fact, disclosed information relating to the use of facial recognition technology to the journalists. In light of that, how does that impact your necessity argument?
Your Excellency, we submit that the termination of Dr. Victoria's employment contract was due to the expressions created by the @Fight for Victoria account, which was established in paragraph 29 of the record, in which she was unilaterally terminated when it was found out that she was behind the account. Now, with regard to the disclosure of confidential information, this would refer to the rescission of Dr. Victoria's permanent residency, in which we submit it was also not necessary and proportionate, especially as the mere act of disclosing confidential material does not automatically mean there is a direct and imminent threat, especially if the matters concerning the disclosed material is about legitimate public interests.
What other measures could have been employed to try to restrict her?
Your Excellency, we submit that Dr. Victoria's expression should not have been restricted at all, especially as it concerned the wrongdoings of the state itself.
May I stop you for a while just and tell me, I'll come back to my first question at the beginning. So basically, if I understand you right, and correct me please if I don't, that what you are claiming is that basically, if you go to academic freedom, if you have a professor in university, be it Oxford University, who is calling for riots, protests of the students, there are disruptions on the campus, students are blocked from entering, there are disruptions. University can do nothing to this professor because this is academic freedom. Or you have other arguments you would say why Victoria's situation is different and we should approach it differently. Or you would claim any person in such situation would be able to claim academic freedom and university can do nothing.
Your Excellency, I will answer your question in two prongs. First, with regard to the disruption that happened in the university, although we recognize that it is indeed regrettable that it had disrupted the access of the students' education, we submit that the disruption of public order is inherent in the conduct of public assemblies. And this has been established in the case of Kudrevicius and others in Lithuania, in which farmers also erected blockades in highways and disrupted public order when they did not allow cars to pass through.
This is a rather different situation. This is an employment situation where a supposedly loyal employee is interfering with the very function that she's employed to further. She's contradicting the purpose of her employment.
That is correct, Judge Warby. And for this, we shall take guidance to the UNESCO recommendation concerning the status of higher education teaching personals, which provides that professors can only be terminated or or dismissed after an internal investigation for just and sufficient causes, and it must be demonstrable before an independent and impartial body or a peer-reviewed hearing within the university. However, if I may direct this court to paragraph 29, Dr. Vittoria was unilaterally terminated without being afforded the right to be heard as well. And Your Excellency,
so that's an alternative argument. So it might have been legitimate for them to do it as long as they'd given her a proper hearing.
Your Excellency, if you...
Yeah. Is that what I understand? You're saying if it was legitimate to terminate her contract because she stirred up dissent and trouble and riots amongst the students, disrupting the activity of the university, then she needed to have a hearing before that sanction
That is
was
correct,
imposed.
Your Excellency.
Yeah.
Even if the court were to find that Dr. Vittoria's acts does constitute a direct and imminent threat towards national security and public order, she must still be afforded with due process.
So, sorry, is the argument that you can only dismiss an academic if they create a direct and an immediate threat to national security? Because that's a rather extreme version of the argument.
No, Your Excellency. However, when it is in response to one's freedom of expression, which is exactly what happened here, the protections of the ICCPR would actually prevail, and therefore there must first be established a direct and imminent threat that would arise to a pressing social need, as well as a proportionality measure. And here, as Dr. Vittoria's termination of her contract did not follow due process, it can be established that it already failed the third limb of the tripartite test when they had terminated her contract.
Can I just take you back to the anonymous? Why have an anonymous act fight for Victoria? Why have that if you could simply express it in another way? Is that not a way of hiding behind something?
Your Excellency, we submit that anonymous accounts are still protected precisely because these individuals may fear being retaliated upon, which is why Dr. Vittoria has hidden behind an anonymous account. Because when NUU had discovered that it was her behind the anonymous account, they had terminated her employment. And likewise, the violation on Article 19 has also extended to the rescission of her permanent residency when the state had rescinded her permanent residency following the UIA's report that she had removed classified and confidential information. Your Excellencies, as established earlier, the mere act of disclosing information does not automatically mean a direct and imminent threat, especially if it is about matters concerning the public at large. And here, if I may direct the court to paragraph 21, Graviola's expose in which Dr. Vittoria was a source revealed that UXI was unlawfully spying on immigrants and deploying facial recognition technology in a way that targeted specific migrant neighborhoods. Your Excellency, we also considered that Dr. Vittoria has a legally imposed duty of confidence, and however, the same case would provide, as well as the Johannesburg principles would provide, that when the disclosure concerns matters of public interest, it can override that legally duty-imposed confidence. Your Excellencies, it is also not proportionate, as even though there is indeed a pressing social need, the rights of Dr. Vittoria were not properly balanced, especially as she had already established a family life in UXI. And we note that the respondents have argued that the seriousness of an offense committed by the applicant is an important consideration when assessing proportionality, where they also cited the cases of Unair in the Netherlands, as well as Kaya in Germany, in stating that serious offenses can justify deportation as well as expulsion. However, it must be noted that both of these cases concern offenses such as heinous and exceptionally violent crimes. In Unair in the Netherlands, this was about a case in which Mr. Unair was convicted of manslaughter.
Sorry to interrupt you, Ms. Laura. What was the status of Dr. Vittoria? Whistleblower, public servant, activist?
Your Excellency, we submit that all of these factors must be taken into consideration. Dr. Vittoria has heightened protection because she is protected with regard to academic freedom, as well as she is also a whistleblower in providing information with regard to the unlawful secrets of the state.
Does one automatically become a whistleblower, or do you need to seek whistleblower status?
Your Excellency, it is not necessary to seek whistleblower status so long as the information is about legitimate public concern and it has been conferred to the press. You are already protected under Article 19.
You only have a few minutes left before your time is completed. Perhaps you can use these remaining minutes to wrap up or make any submissions you have not yet had an opportunity to make.
Thank you, Madam President. Now, the same is also violated, Articles 19 and 17, when Dr. Vittoria's digital devices were monitored in paragraphs 19 and 20. And Your Excellencies, it must be noted that these sanctions must all satisfy the tripartite test, in which these tests are cumulative. Therefore, just the failure to satisfy even just one of them would already constitute as a violation of Articles 19 and 17. Your Excellencies, if I may be of no further assistance to the court.
Thank you.
This concludes my...
Just last question, from my side about permanent residency. She has a residency in Jambo. She's citizen of Kamapu. Does she have a right to residency in Uksi, basically? Can she actually claim such right? Do you have a right, if you are a citizen of another country and you have a residence in the third country, can you actually claim to have a residence right as such in a different country?
Your Excellency, that would depend on the domestic laws of certain countries, and nothing in the facts would establish that Dr. Vittoria is prohibited to acquire another residency in a different country. And even though Dr. Vittoria has residency in Jambo, this would not provide that she had the intent of leaving UXI in itself, especially as in paragraph 15. Dr. Vittoria had explained that she had been merely granted a residency permit. I note my time, Your Excellency, if that answers your question.
Thank you.
Thank you for your indulgence. May it please the court.
Thank you for your presentation, Counsel.
Time flies.
Good morning, Counsel. You may place yourself on record.
Thank you. Good afternoon, Your Excellencies, Madam President, and may it please the Court. My name is James Staines, and along with my co-agent, Alyssa Music, and CRER of Counsel, I appear on behalf of the Respondent, the State of Uksi, in this matter. We'll be allocating 22 minutes to myself, 21 minutes to Ms. Music, and reserving 2 minutes for our right of rebuttal. Your Excellencies, this case is about the lawful and proportionate measures taken by the State of Uksi to balance its national interests, territorial rights, and the rights of its 8 million citizens. In the face of a serious and documented transnational threat arising from organized criminal entities, the State of Uksi went to great lengths to ensure that it was able to protect those rights and protect those interests while minimally impairing the rights of the applicants. These measures were then carefully reviewed by the Constitutional Court of Uksi and found to be both lawful and proportionate in their effects.
I'm just surprised, Mr. Staines, that you used the word minimally impairing, where somebody's residence is revoked, where they lost their employment. I'm not sure you can use the term minimal.
Your Excellency, or Madam President, when I refer to the term minimally impairing, I'm referring to it in the standards of the tripartite test that requires the justification for interference, and requires those standards to be minimally impairing while also being effective to achieve the legitimate aim. And my co-agent will submit why the sanctions imposed on Dr. Vittoria with regards to permanent residency and determination do meet that standard of minimal impairment. Your Excellencies, we have 2 submissions before the court today. First, I will submit that with regards to Graviola, the interferences with her Article 17 and 19 rights were justified under the ICCPR, and Ms. Music will then go on to submit the same with regards to Dr. Vittoria. Your Excellencies, the State of Uksi concedes that it interfered with the applicant's rights in this matter. The point of contention between applicant and respondent arises over whether or not this interference can be justified. And the test for justified interference is exactly as the applicants have correctly laid out. It requires the state to demonstrate 3 things. First, that the interference was prescribed by law. Second, in pursuit of a legitimate aim. And finally, that it was necessary and proportionate for the pursuance of said aim. Our submissions will be structured following that three-part analysis, and we will deal with the Article 17 and 19 rights at the same time, rather than switching between the two. For clarity, Your Excellencies, if I'm referring to UNSA, I'm speaking about the Article 17 rights of graviola, and if I'm referring to the FPA or the Injunction on Broken Code, to the Article 19 rights at hand. If we can turn to the first prong of the analysis, we can see in the cases of Roman Zakharov in Russia before the European Court of Human Rights, as well as Kimmel in Argentina before the Inter-American Court of Human Rights, that the prescribed by law standard requires three things.
Sorry that I'm interrupting you, Counsel, but before you go to three-part test, you don't question that the rights of graviola were interfered with under Article 17. So
Your Excellency, we acknowledge that the rights of graviola were interfered with under Article 17, and that happened as a result of the search of Dr. Vittoria's laptop at the border.
Okay.
Given the focus should be on the sort of ICCPR, do you have any authorities from the Human Rights Committee to support these tests and what you're about to argue?
Absolutely, Your Excellency. We can see in the case of Malcolm Ross in Canada, for example, which was before the UNHRC, that this same tripartite test was applied, and it is also applied across the three regional bodies in Africa, Inter-American, and European courts. Your Excellencies, just quickly, with regards to the aspect of accessibility, the applicants have not contested it, and so I'll be brief here and just state that both the FPA and UNTA are accessible domestic law. Furthermore, the applicants have advanced no arguments with regards to the prescribed by law standard regarding the FPA. And as such, I will just quickly note that at Article 10, sub 5 of the FPA, we can see that the exact type of sanction that was imposed on broken code was contemplated by the law as a prior restraint. Moreover, this sanction requires a court order for its imposition, and as such is adequately safeguarded against arbitrary application and satisfies the final requirement. If we can turn to UNSA, we can also see that this is a robust piece of legislation, and it contains in great detail the applicability and scope of the law. Specifically, Your Excellencies, if you turn to paragraph 12 of the facts and look at Article 1 of UNSA, we can see that it defines a subject of interest and limits the applicability of the law to only those persons. Moreover, in Article 1, sub 5, there are further constraints that are placed on the status of a subject of interest to determine when their rights may be interfered with. Specifically, Your Excellencies, if I can take you to the Article 1 definition, it reads, a subject of interest is defined as those who present a threat or against whom there is reasonable suspicion that they could present a threat to UTSI's national security. And this is further limited by Article 1, sub 5, which reads, who makes or who threatens to make a damaging or unauthorized disclosure of any information, data, or document or other article.
Well, the case against you is about the vagueness of the term national security, rather than the points that you've been focusing on. What do you say to that?
So, Your Excellency, I have two responses to that. The term national security is allowed to be vague in this context, as courts are allowed to flexibly interpret such terms. We can look to the case of Chauvy and others v. France, in which the European Court of Human Rights allowed for this flexibility. And Judge Murray, I believe this goes to a question that you posed to the applicants about the standard of absolute certainty. So I'd also like to direct the court's attention to the case of Umahosa in Rwanda before the African Court of People and Human Rights. And in that case, the provision at hand that was challenged for being prescribed by law read as follows. Any person who by any means incites the population to commit acts of violence, to disturb public order, or harm the security of persons and property. This law was found to be prescribed by law. And Judge Warby, I'm sure you can appreciate here that the term public order, being the legitimate aim in that case, is also not defined within the law, and the court found that there was no issue with that because the domestic courts are able to apply the law flexibly in that context and provide that definition themselves.
Just taking you to that case, that was a very specific context which was actually acknowledged by the African court, which is not the same as the context here. And just following up, and the court acknowledged that, so just following up on Justice Warby's point, in addition, the lack of clarity on the wording interests of UTSI, could you say a little bit more? That's incredibly vague. How does that satisfy the test?
Judge Murray, I will answer the two parts of your question in turn. So first, with regards to Umahosa, you are correct to identify that it was in a particular context, and it was specifically in the freedom of expression context, not the privacy context, as UNSA would be mainly targeted at. However, the principle remains the same, and that the principle is that there can be flexible interpretation, and we can see that across other cases, like Chauvy in France and others, Chauvy and others v. France, as well as the case of Roman Zakharov in Russia. This flexibility is consistent across the applications throughout the courts. To answer the second part of your question about the other interest aspect of the end of the Article 1, sub 5 definition, we can see here that what this is actually referring to is still the aim of national security. Article 1 sub 5 is prefaced by the requirement that a person be classified as a subject of interest. And the persons who can be classified as subjects of interest can only be classified in that manner if they threaten national security. And that's specifically in the definition of Article 1. So while it might say other interests, we should still be viewing this in the national security context and understanding that the drafting in this manner is to allow the domestic courts to have this flexibility in interpretation because the law cannot possibly envision every single interest that might go to national security.
Counsel, I have two questions for you. Was Graviola classified as a subject of interest? And the second question relates to General Comment 34 of the Human Rights Committee, which states that a law may not confer unfettered discretion for the restriction of freedom of expression. Does the wording of UNSA not allow for such unfettered discretion in the monitoring of particularly the journalist communications?
To answer your first question, Madam President, Graviola was never designated a subject of interest. The only subject of interest was Dr. Vittoria. And to your second question about the unfettered discretion and the prohibition of it under General Comment 34, if we look at the terms that are actually present in the law here and read them in their entirety, we can see that while the law might start in a relatively broad sense, there are multiple constraining factors. First, we must be in the landscape of national security. Second, the person who is contemplated as a subject of interest must have information or documents that the government deems confidential. Additionally, they must also be seeking to make a disclosure of those comments. And finally, that disclosure must be unauthorized. So while we start in this broad terms, we end up in a very small zone of reasonable foreseeability, and that creates the precision that prevents against unfettered discretion. Moreover, there are adequate safeguards against the arbitrary application that are built into the provisions of this law specifically. Before I address those adequate safeguards, I would like to address some of the questions that the court has had with regards to the status of wiretapping here. Madam President and Judge Warby, you asked specifically what facts give rise to the applicant's claim that there was monitoring that went beyond the initial search at the border. And specifically, Your Excellencies, I would like to direct you to paragraph 31 of the facts, at which we can see that Dr. Vittoria advanced claims of wiretapping before the Constitutional Court of Uxie. If you then turn to paragraph 32 of the facts, you can see that all of her claims were rejected. Your Excellencies, a court of first instance with a better view to the factual record than this court can replicate rejected the claims of wiretapping, stating that there was not evidence to support it. Moreover, if we look at paragraph 20 of the facts, we can see that the evidence of wiretapping in this case is, quote, beeping and scratching. Your Excellencies, this is not enough to create a reasonable suspicion that wiretapping has occurred. And to that point, I could direct the court's attention to the case of Ilya Stefanov in Bulgaria before the European Court of Human Rights, in which, quote, disturbances on the line were not sufficient to create reasonable suspicion of wiretapping. We would submit that beeping and scratching and disturbances on the line are in the same vein of not sufficient in this matter. If I can turn now to the issue of adequate safeguards, we can see here, as Madam President, you noted that the INST is built in as an adequate safeguard under Article 80 of UNSA. This is sufficient as a level of independent judicial review in the form of an administrative tribunal. If we look to the cases of Malcolm Ross in Canada before the UN Human Rights Committee, as well as Unzen in Germany before the European Court of Human Rights, we can see that this first level of administrative review is sufficient to create an adequate safeguard. Moreover, in this case, there was also a secondary level of judicial review of that initial decision by virtue of an appeal to the Constitutional Court of Uxie. And in fact, in this case, that jurisdiction and that appeal was exercised by the applicants. As such, we see the type of double-barreled administrative and judicial review that was found to be a sufficient safeguard in the cases of both Unzen in Germany and Malcolm Ross in Canada. And so, Your Excellencies, we would submit that the first step of the analysis, the prescribed by law standard, is met with regards to both the FPA and UNSA. Your Excellencies, if I could turn now to the second requirement being that of legitimate aim. And again, as the applicants have not contested it, I will endeavor to be very brief in my analysis here. But it's important to frame what the legitimate aim is for the necessity and proportionality argument, so I will do so now. The legitimate aims being pursued by both the FPA and UNSA, and the injunction and the interferences here, were the legitimate aims of national security and public order. And if I could direct Your Excellency's attention to paragraph 6 of the facts, we can see at paragraph 6 that the cartels in Kamloops once implemented in neighborhoods, are trafficking synthetic opioids. They are introducing high levels of street violence as well as high per capita homicide rates. And furthermore, once these entities have taken root in these neighborhoods, they are almost impossible to remove from these neighborhoods. The Kamapuan military and police forces have been unsuccessful in removing them. This is exactly what UCSI is trying to prevent from happening to its own neighborhoods and its own communities.
It was argued against you that paragraphs 6 to 8 of the facts don't reveal anything that's going on now, and that this is a historic problem, illustrated by the seizure of drugs in 2023. What do you say to that?
Your Excellency, even if there has not been a significant seizure since that 2023 bust in February, there is still the threat of these cartels operating within this continent, and there is evidence from the UIA commissary and their own intelligence operations within UCSI that suggests that this threat is ongoing. If we look at paragraph 7 of the facts, we can see that it's also established that some of these cartel members have infiltrated UCSI and have taken up activity within UCSI neighborhoods. And that's the threat that we're trying to prevent from spreading, and we're trying to prevent those cartels from taking root so that they can be stopped from harming the public order as well as the national security of UCSI. With these national security and public order interests in mind, we can now turn to the final requirement, being that of necessity.
Just if you can stop you for a while. I understand the concerns about national security and drug-related issues, but I think the applicant never challenged that. If you look at the paragraph 17 and the very last sentence after the conference, she basically said either the state should regulate face recognition technologies or ban it. So basically, she is raising the debate about regulation of these type of technologies and making them known to public rather than saying the state cannot fight with illegal drug organized crime.
She absolutely is, Your Excellency. And you'll note that when she's making those comments and appearing at conferences on new technologies at NUU University, the state has not intervened with her ability to freely express herself. It is only when she disclosed confidential information to Graviola, and then that confidential information was going to be published by Graviola in the form of an expose, that the state has felt the need to intervene. The concern is not with the discussion of facial recognition technology, but with the leaking of confidential security strategies that the state is implementing. And
I'm not clear what those strategies are from the facts that we've got. I mean, we see that the state argued that there was a problem, but we're not told really what the problem was or why it was, why the disclosure was threatening national security.
Judge Darby, and this really goes to the necessity of both interventions. And I would like to direct the court's attention to paragraph 22 of the facts, at which we can see the quote that the commissary argued, if published, the expose would threaten UCSI's national security by revealing sensitive and confidential information about the security and intelligence strategies of UCSI. And Judge Darby, I believe your concern is that this is an argument rather than a finding of actual fact.
That's right, or at least it's an argument based on some facts that aren't revealed.
Absolutely, Your Excellency. However, if we turn to paragraph 32 of the facts, we can see that this argument was accepted by the Constitutional Court of UCSI and is a found fact as such. Moreover, and I believe this might be going to your larger concern, Judge Darby, or Judge Barbie, sorry, which is that the state is not revealing this sensitive information that is being addressed here, and so how can this court assess what that information entails and if it will reach national security issues? However, Your Excellencies, this is not the burden that the state has to meet. In the case of Klaus in Germany before the European Court of Human Rights, we can see that states have an interest in maintaining a shroud of secrecy over their intelligence operations. And it creates an unreasonable burden on the states to be forced to disclose those strategies and those technologies in order to justify the use of those systems. And as such, we do not have to meet the burden of demonstrating specifically what was in the confidential documents or what was in the expose that was threatening. Moreover, to do so would be counterintuitive, as it would require the state to essentially confirm exactly what strategies they are implementing by picking which content they choose to ban and which content they do not choose to ban.
Can I just take you back? You said initially that this was on the basis of national security and public order, but
Yes,
what you seem to be focusing on is the national security. So could you talk more about the public order element?
My apologies, Your Excellency, for not making clear. But the reason that distinction seems to have collapsed in this case is that the events giving rise to both public order and national security are the same in this context. So if we turn to General Comment 34 at paragraph 31, we can see that the UN Human Rights Committee in that general comment defines public order as being concerned with the public safety, public health, and the ability of citizens to live their lives more generally. And as such, we can see that the influence of these drug cartels would impact that public order by negating the public safety. And as such, the same intervening incidents that give rise to the national security concerns give rise to the public order concerns.
But that's quite a stretch, isn't it? Particularly if you go back to the question about whether this is a real current threat.
Your Excellency, we would submit that this is in fact a current threat, and that's what the intelligence of UXI seems to suggest at the present matter. However, even if you do not accept that there is a public order concern here, there is definitely a national security concern. And the state does not need multiple grounds of legitimate aims. One is sufficient, and we would base the entirety of our arguments on that national security branch if you're not convinced on the public order aspect.
Mr. Staines, if I understand the submission of the respondents is that UXI's blocking of the broken code was the least intrusive means and was not overbroad here. Is that right?
Yes, Your Excellency.
Now, I didn't hear the respondents suggest that anything else on the website other than the expose presented a danger or a threat to UXI. So, was it necessary or was it proportionate to block access to the entire broken code website?
So, Your Excellency, to answer that in the two parts that it's been presented, it was necessary to do so because Graviola is the editor-in-chief of Broken Code, and she exercises near unilateral control over what content it publishes. And as such, the risk is not to the specific article, but rather to the publication she controls and her ability to direct information into various articles that might be published on that platform. And I think the broader concern here is the proportionality, Madam President, if I might suggest that. And when we look at the proportionality aspect, what we're looking at is for three things: that the interference be the least intrusive means to be effective, that it not be overbroad, and that on the balance, it do more harm than detriment to the person whose rights were interfered with, or do more benefit than harm to the person whose rights were interfered with. So if we look to the aspect of the least intrusive means to be effective, we can see that this is the only means that would be effective in this case. As aforementioned, Graviola is the editor-in-chief of Broken Code, and as such, she can filter this information into other articles, and as such, a content-specific ban might not have been sufficient in this case.
Sorry, if I may. So the ban was implemented before publication.
Yes, Your Excellency.
And that sort of goes back to your earlier point that how were you able to assess the content of the expose prior to publication? It sounds a bit more like this is being couched as a reputational or political embarrassment concern rather than a genuine national security threat. How do you know the contents unless it's been published?
Your Excellency, I have two responses to that. So the first is that the contents of the expose were determined after the interference with Dr. Vittoria and Graviola's privacy interests with the airport search of the laptop. And then secondly, the practice of UXI has not been to disallow embarrassing publications. Specifically, it has not been to disallow the embarrassing publications of Graviola. She has published exposés about the UXIan government outlining corruption that the state was engaged in, and there have been no interferences with her rights here. What we are concerned about is stopping the dissemination of confidential information specifically. We only interceded when that confidential information that can threaten the national security and put the lives of 8 million UXIans at risk was going to be disseminated, and that's why the ban was implemented in this specific case. Madam President, to return to your question about lesser intrusive means, we can see here that the applicants have suggested some of these less intrusive means. Specifically, they suggested that content filtering in the form of URL filtering or a notice and takedown-like scenario in which we reached out to Graviola might have been effective. However, with regards to the notice and takedown scenario, we can see here that this creates a broad risk which is unacceptable given the gravity of the national security concerns here. If Graviola chose not to comply with that procedure and instead publish the information anyways, the information would be up online and be forever able to be recaptured by the state. Moreover, we can see that any post facto analysis and limitations, such as URL filtering or other content-specific measures, require the information to be published first. And again, this is an unacceptable risk for the state of UXI to have engaged in here because the lives of its 8 million citizens are threatened as soon as that publication is implemented in the first instance.
And Graviola is where? She's in Jambo. She's not in UXI.
Your Excellency, it's not clear on the facts, but she publishes from Jambo. I believe that's where the Broken Code website is.
Yeah, I think that we're told in 16 that the organisation is based in Jambo.
Yes, Your Excellency.
Mr. Staines, I think you're almost at the end of your time. I'll give you a minute to wrap up or make any submissions you have not been able to before.
Thank you, Madam President. I would just briefly like to touch on the proportionality of the interference based on the border search, and just note that this interference with Graviola's privacy interests happened as an incident to a lawful search conducted on Dr. Vittoria. And as such, she has a minimized impact of that breach, and it was very proportionate in its effects because of that. Your Excellencies, in totality, the measures that were taken by the state of UCSI were both lawful and proportionate because they were the least intrusive means to be effective, they were not overbroad, and they were proportionate in their effects. Combined with the pursuance of a legitimate aim, as well as the establishment of a clearly prescribed law with regards to UNSA and the FPA, the rights of the applicants were interfered with, but they were done so in a justified manner by the state, and we have met our burden with regards to Graviola. If I can be of no further help to the bench, I'll yield the podium to my co-agent to deliver submissions for Graviola, or Dr. Vittoria.
Thank you for your presentation, Counsel.
May I proceed?
Counsel, you may proceed.
Good morning, Your Excellencies. May it please the Court. My name is Alyssa Gillespie-Music, and I'm appearing on behalf of the respondent, the State of UCSI, alongside my co-agent, James Staines. I will be continuing UCSI's submissions and will submit that any interferences with Dr. Vittoria's Article 17 and 19 rights were justified under the ICCPR. Your Excellencies, the respondent acknowledges the immense importance of freedom of expression and privacy in a democratic society. However, these rights are not absolute. International law permits interferences with these rights when their exercise adversely impacts the rights and interests of others. And that's precisely what has happened in the case before you today. UCSI concedes that there has been interferences with Dr. Vittoria's Article 17 and 19 rights.
So is it your submission that we're dealing with the balancing of rights?
Yes, Your Excellency. The state has the burden to balance the rights of all, the interests of all of their citizens against the rights of the applicants before you today. And ultimately, it is our position that the state balanced them correctly in this case. In terms of the structure of my submissions, I will follow the same three-pronged test outlined by my co-agent, and will first submit that interferences with Dr. Vittoria's Article 17 and 19 rights were prescribed by law, second, that they pursued legitimate aims, and third, that they were necessary and proportionate to achieve those aims. For clarity, when I'm discussing the Article 17 interferences, I'm discussing the interferences with her devices and the revocation of her permanent residency. And when I'm discussing the Article 19 interferences, I'm discussing the termination of her employment as a result of her online activity as Fight for Vittoria. Turning then to that first submission. Interferences with both Dr. Vittoria's Article 17 and 19 rights were prescribed by law because the UNSA was publicly accessible, sufficiently precise, and possessed adequate safeguards against arbitrariness. Your Excellencies, as the applicants haven't contested accessibility, I will also not make submissions on that point. And as my co-agent has already outlined the facial clarity and the sufficient precision standard, I will also not make submissions there. But I would like to clarify why this law was sufficiently precise in application to Dr. Vittoria.
In terms of the safeguards, there's no safeguard as to the period of monitoring. Isn't that a difficulty?
I understand your concern, Your Excellency. I would like to note, while there are some temporal safeguards in Article 10, Sub 10 with the retention of data, I recognize there is no provision in the law as to how long an interception can occur for. However, that is not fatal to the respondent's position in this case. While we understand there is case law specifically from the European Court of Human Rights that lays out minimum safeguards, when looking more broadly at the standard of what we actually need to meet sufficient precision in this law, we can even see in Roman Zakharov that standard is, at paragraph 229, that a law must be sufficiently clear to give citizens an adequate indication as to the circumstances in which and the conditions on which public authorities are empowered to resort to any such measures. That is met here, but even if you aren't with me on that, when we look to General Comment 16, which is the primary interpretive document when we're looking at Article 17 rights, which is specifically what is at issue here. It is not Article 8 of the European Convention. It is a much broader standard, and this minimum safeguard is not an absolute requirement. In turn, then, of turning back to the question of application of the law to Dr. Vittoria, the controlling question here is really, could Dr. Vittoria regulate her conduct in accordance with the law? And it is our submission that the answer here is a resounding yes. It should have been reasonably clear at the point at which Dr. Vittoria removed classified documents from the Ministry of Science and Technology, which is confirmed at paragraph 25 of the facts, and provided them to a journalist for the purpose of an expose. She rendered herself a subject of interest. But even beyond that, there is a clear pattern and shift in her behavior that gave the government reason to believe she was a subject of interest before any interference occurred. I would like to turn your excellencies to paragraph 15 of the facts because I would like to walk through the timeline here in some detail. At paragraph 15, we can see that in April 2025, Dr. Vittoria resigned from her position at the Ministry of Science and Technology, saying she was unhappy with some of their policy positions and moved immediately to Jombo. Subsequently, in May 2025, she started posting online about the use of facial recognition technology. When we then turn to paragraph 17 of the facts, we can see that she returned to the National University of UXI for a conference where she presented a paper specifically on UXI facial recognition technology and the migratory crisis. And despite the fact that at that conference, when asked about whether or not UXI was using facial recognition technology, she said she couldn't comment on it and cited her confidentiality obligations. The very next day, she liked a comment that I would like to read to you in its entirety, and it's located at paragraph 18 of the facts for your convenience. That comment says, "I think this means UXI is already deploying these technologies. This is sad. I think we need to mobilize and do something before it's too late." The accumulation of all of these activities gave the government reason to believe that Dr. Vittoria, an individual who had access to confidential information, could be rendered a subject of interest.
So can I just clarify, at that stage, she is a subject of interest then?
She made herself a subject of interest, or could be reasonably perceived to be one.
But there were 200 other users who also liked the comment.
Certainly. I imagine your concern is, does that mean everyone could be a subject of interest, anyone that comments? And there's a key distinction here, and I would like to answer this in two parts. First, I'd like to tell you why her like was actually significant. When we look at European Court of Human Rights case law, and specifically the case of Malek in Turkey, we see precisely what the court tells us about the status of a like on social media. And that is that it is the status of the liker that can imply significance. Which brings me to the second part of this analysis. Dr. Vittoria is not just an average social media user. She has 1 million followers, but more than that, she had classified information and was well recognized as a member of the Ministry of Science and Technology. Put simply, her like is significantly more significant than the like of someone else. That is why that matters in this case. So ultimately, Your Excellencies, when we take the fact that the UNSA was accessible, sufficiently precise, and possessed adequate safeguards as laid out by my co-agent, all interferences were lawful. This brings me to the second prong of the analysis, whether or not interferences pursued a legitimate aim.
If I can still keep you on a law about the search and seizure of her data at the border, you said it's according to law, and does the law, I want to ask, does it go to international standards, ICCPR, and also European Convention of Human Rights, that you can actually access the correspondence between the person, the source, and the journalist, and read this correspondence without the warrant of the judge, which actually it seems to be Article 40 allows if we look at the paragraph 19. Is that not contravene the standards the Strasbourg court set in Goodwin and other cases?
Could I clarify your question, Your Excellency?
The question is whether the fact that police can access, not only access electronic devices, but read the correspondence between the source and the journalist without the judge warrant, whether this is in line with international standards, Human Rights Committee or ECHR, if we take Goodwin versus UK and other source protection cases?
My answer to that, Your Excellency, is yes, it is. And the reason for that is because at the time that they intercepted her devices, they weren't necessarily aware that she was a source. By that standard, that means that we could never interfere with anyone's communications ever, lest they be a source for a journalist. That connection was only discovered through the interference.
Okay, but if I may, I stop you here. At the time when they start to read, they see that there is a communication with a journalist. Should they continue reading it, or should they ask for the judge warrant?
While I understand that in many instances it might be preferable to ask for a judge order, it is not a hard requirement, and the respondent's failure to do so does not compromise our position in this case.
Thank you.
Turning back then to legitimate aim. As my co-agent has already outlined, interferences with Articles 17 and 19 rights for Dr. Vittoria pursued the legitimate aims of national security and public order. There is one final point I would like to make on this, though, because it does factor into the analysis on proportionality later, and that is specifically the role of synthetic opioids in this case. The Kamapu cartels, which are the cartels that UXI is very concerned about, traffic synthetic opioids. The UN Office on Drugs and Crime have noted that synthetic opioids are by far the most dangerous drugs and most harmful as they are associated with exceptionally high mortality rates, since people can rarely tell you what is actually in these drugs to begin with. They're also associated with extremely high rates of violence, and we've seen those in Kamapu. And if I could turn you to paragraph 6 and 7 of the facts, we can also see that once these cartels take hold of an area, they are nearly impossible to expel. In fact, as per paragraph 6, Kamapu has tried to deploy both the army and the police force to get rid of these cartels and have been unsuccessful in doing so. So there is a real threat. And again, to the point that Judge Kamel, you raised to the applicants, even if the risk hasn't materialized yet, there can still be a legitimate aim in national security.
Can I just... So the point at which she stopped, what's the legitimate aim there? So you both talk about national security and public order. Are you saying the public order element as an aim applies at that stage as well, or is this just national security?
It applies differently to the different interferences. So the termination of her employment, there's more of a public order dimension than there is with, for instance, the initial interception. However, as my co-agent noted, even if you aren't convinced on the public order argument, the national security is sufficient, particularly for Article 17. But Article 19, there's a further legitimate aim that was pursued. And this is the rights and reputations of others. Specifically, what I'm talking about here is the right to education, which is enshrined in Article 13 of the ICE SCR. General Comment 13, which interprets this document, imposes positive obligations on the state to prevent third parties from interfering with the enjoyment of this right. And this necessarily includes the access of physical institutions and educational institutions. This was compromised in this case and serves as a further legitimate aim to justify the termination of her employment.
Yes, I struggle somewhat with that, Ms. Lizzie, that the termination of Dr. Vittoria's tenure and the rescission of her permanent residence were necessary and proportionate. I struggle with how these measures, which relate to her academic activities, could meet the legitimate aim of the government.
So first, Your Excellency, I'd like to clarify that the sanctions were not actually targeting her academic activities. The sanctions here were again targeting an unauthorized disclosure of confidential information, and as I will discuss more thoroughly in my necessity and proportionality analysis, her creation of an account specifically to protest her employment status at a university.
And then the rescission of her permanent residence?
I'm happy to take you there right now if that would, I understand that is a difficult sanction. So in terms of the interference with Dr. Vittoria's family life, this is properly categorized as an Article 17 right. And UCSI concedes that given Dr. Vittoria had an UCSIan spouse and an UCSIan child, there is such an interference. And indeed, there is significant hardship posed on the applicant. However, the controlling question here in assessing whether or not the rescission was justified was not whether or not there was hardship suffered, but whether or not the rescission was arbitrary. And I would like to point out to you why it was not. In the case of Unner in the Netherlands, the European Court of Human Rights laid out a series of factors to consider in conducting this analysis. The first is the seriousness of the offense. While we understand the applicant cited to you some cases from our memorial that consisted of significantly more serious offenses, they don't need to be violent or even criminal in nature to be deemed sufficiently serious. I would like to turn Your Excellency's attention to the case of Alale and others and Norway. In that case, the applicant had lived in Norway for 20 years, had a Norwegian spouse and a Norwegian child, and had initially lied on her permanent residency application about the country that she came from. However, the court noted this was sufficiently serious to constitute upholding the rescission of her permanent residency, given the threat to public order, and essentially for a deterrent effect. I would like to contrast that. I'm sorry, I see you
May I
have
stop you here just for a while? You think seriousness of offense, but she, if I'm right, she is not convicted. The trial is just undergoing. How can we assume that she will be convicted? So maybe the result will be she will be acquitted and there will be no criminal conviction.
Your Excellency.
If I may just jump on that, what I'm struggling with is why all three measures, so why surveillance, dismissal, and the residency rescission, why wasn't it sufficient to suspend her, for example, from her employment or to suspend her residency until pending investigation?
Certainly, Your Excellency. And if I may take your questions in reverse order, as I think that might be most helpful. In terms of why all three measures were important, it's because they all actually targeted different activities. The termination of her employment was not for leaking information or exposing confidential information. In fact, when that information was shared with NUU, she was simply suspended. The termination only occurred after it was discovered she was behind Fight for Victoria and essentially drummed up public discontent as a result of her own employment status. The rescission of her permanent residency is linked to that disclosure, and that again takes me back to the seriousness of the offense, and I'd like to lay out for you exactly why that is important here. What she did when she leaked that confidential information was risk that confidential information reaching the hands of the cartel. At the point it did, and at the point it risked frustrating the efforts of UCSI and national security to prevent the cartel from interfering with the rights of all citizens in UCSI, all 8 million citizens, we see that again we're in this situation where we have to delicately balance competing rights. Again, we recognize this as an interference, but the state also has to consider the rights and interests of those residing within their own state and the dangers posed by this cartel. That is why this is so serious and why this sanction is appropriate for this measure. But there are other factors we consider. That is continuing conduct, which we can see again at paragraph 23 of the facts when Dr. Victoria liked a further comment that said, they are silencing her because they think she wants to reveal the truth. Facial recognition is already here. If you are living in a Kamapu neighborhood, think twice before leaving the house, or maybe it's time we start to break some cameras. Again, we recognize there are other factors we balance, including family interests and the best rights of children. However, these are not necessarily determinative factors, and again, I bring you back to the Alalea Norway case with quite analogous facts. In this case, when the state had to balance a range of competing factors and a range of competing interests, they did so appropriately to protect the rights of all citizens that live within their border.
But in all these cases you mentioned, the persons were convicted or the trial was under investigation?
Thank you for bringing me back to your question, Your Excellency. In not all of the cases were they even criminal cases. Again, going back to the case of Alalea in Norway, this was not a criminal conviction, so a criminal conviction is not necessary to establish this standard. Before moving to termination, I would just briefly like to address the question of the monitoring or retention of her computer. And
sorry, can I just take you back to the point about, you said that the termination of employment was because she drummed up public discontent, but actually the investigation and her suspension was in relation, it would appear if you look at the facts of the case, because she'd like to comment by an anonymous user in terms of facial recognition and so on. So this is prior to any concerns around protests.
So I will go to necessity and proportionality for termination, just because I think that is where the court's attention is, and I do want to address this point quite clearly. In terms of the initial suspension, if we go to paragraph 25 of the case, this happened only when the National University of UCSI received confirmation by the UCSIan Intelligence Agency that she had disclosed confidential information. She was suspended pending an investigation. But then what is really critical here, when we turn to paragraph 29 of the facts, she was only terminated at the point at which she was revealed as being behind the Fight for Victoria account. And I'd like to lay out the timeline of the Fight for Victoria account and why this is so clearly within the realm of an employment-related sanction, as Judge Kush and Judge Warby, I believe you raised with the applicants. Let's look at the timeline here. The Fight for Victoria account was created on the 1st of February. On the 1st of February, Dr. Victoria posted in her personal account that she had been suspended by the university. This was true. On the very same day, she created Fight for Victoria, an anonymous account, implying people should be quite literally fighting for her. And she posted that she was fired in retaliation for speaking out. These are two incredibly different sentiments. This account reached 1 million people within 5 days. That is actually twice Dr. Victoria's actual reach. And people responded to her calls to fight for her. And this is important again when we think about the context of the state having a positive obligation to discharge other people's rights, particularly the right to education. This was necessary in this context, and quite particularly, this is about an employer and an employee. This is not about what she said about facial recognition technology, but rather about the fact that she drummed up protests in support of her employment status on the basis of a fabrication. When we then go to the proportionality of that sanction, because we do understand the concern that termination can be quite harsh.
Just before you go to proportionality, Ms. Music, you talk about she drummed up influence and the protests. What do you say about the fact that only residents from Kamapu was detained after the protest?
We understand.
Is there any significance in that?
No, Your Excellency. However, it isn't actually our position that that is what made the protest so bad. It was simply that the state has a positive duty to ensure that students are able to access the institution, and Dr. Vittoria, as Fight for Vittoria, posed a continued threat to those disruptions, particularly given the fact she had a following.
Why were only people from Kamapu detained?
While we understand that is a challenging fact for us, it is not one that necessarily bears on the determination today. In terms of why that was a proportionate sanction, though, the termination struck a fair balance between Dr. Vittoria's expressive interests and the competing rights and interests at stake. And particularly, it served an employment relationship interest. In the context of freedom of expression and employment, we can see in the case of Palomo Sanchez in Spain, at paragraph 76, employment relationships must be built on mutual trust. Certain manifestations of the right to freedom of expression that may be legitimate in other contexts are not legitimate in the employment context, and in that case, a termination was upheld. This is the same in this case. There is no longer that mutual relationship of trust, and the institution had to sever their ties in order to restore institutional legitimacy. And further, she could continue to post. There was no order on that, but she simply could not continue to express herself as a member of the university whose rights she violated.
I welcome you now to wrap up your case and make any points you haven't had the opportunity to make.
Thank you, Your Excellency.
In the last minute.
I will briefly note that her interferences with her laptop, one device was retained, and that was again in pursuit of the legitimate aim of national security. And I will take Your Excellencies to the conclusion of my arguments. Essentially, we understand this is an incredibly complicated case. However, given all of the information that UCSI had at hand, they appropriately and delicately balanced the competing rights and interests of the 2 applicants before you today and the 8 million citizens that reside within their borders. Ultimately, that means any interference with Graviola and Dr. Vittoria's Article 17 and 19 rights were justified under the ICCPR, and as such, we ask that you dismiss both applications in their entirety. If I may be of no further assistance to the bench, those are my submissions.
Thank you very much for your presentation, Counsel. You may proceed, Mr. Dava.
Your Excellencies, 3 points of rebuttal. First, the first respondent counsel argued explicitly that Graviola is not a subject of interest, only Vittoria. But at the first breath, they conceded that the rights of Graviola were interfered with, and they reiterated this as a response to Judge Cooch when they monitored her communications under the UNSA. First, this is inconsistent because Article 1 of the UNSA explicitly states that it only applies to subjects of interest. Second, this is dangerous because if the respondent concedes that the privacy of a person not considered a subject of interest can be interfered with, first, on what basis? And second, imagine what they can do to a subject of interest. Second, Your Excellency, with regard to proportionality, they argued that the blocking is the least restrictive measure. But as argued by the respondent themselves, Graviola is the editor-in-chief and has unilateral control of the Broken Code website. If I may take you to clarification number 4, it was Graviola's team who voluntarily took down the website or the expose worldwide during a 10-day period. And this 10-day period, Your Excellencies, UCSI never communicated, negotiated, nor reached out to Graviola. Had the team not taken down the website or the expose worldwide, then UCSI never would have reopened the access to the Broken Code website. Notably as well, Your Excellencies, during that 10-day period, the expose was available worldwide, and therefore the threat to national security being protected is diminished because cartel members outside of UCSI would have had access to such information. Third, they argued that the sanctions target the security threat, which is the disclosure of confidential information. But that is not the case here, Your Excellencies. Victoria's communications here and her disclosure of information regarded information of legitimate public concern recognized as protected speech under the 2004 case, Inter-American Court of Human Rights, Canessa and Paraguay, and the 2008 case of Guha and Moldova. Graviola, Vittoria in this particular case, ought to be protected with regard to their Articles 17 and 19 rights. For these reasons, Your Excellencies, and accordingly, we pray that the court find in the applicant's favor.
Thank you, Counsel. You may proceed, Mr. Staines.
Your Excellencies, I'll address the 3 points on rebuttal here. First, with regards to the security threat of the disclosure, the applicant is seeming to suggest that the expose did not contain confidential and sensitive information that would harm national security. However, as identified by the respondent in our submissions, as a found fact by the Constitutional Court of UCSI, this is simply not the case, and the expose did contain that confidential information, which necessitated its ban. This leads me to the proportionality point that the applicants have made on rebuttal. They have stated that Graviola has voluntarily removed her expose as a justification for why the state could have reached out to Graviola before the injunction was imposed to have her take down or not publish the expose. However, Your Excellencies, this creates a real risk to the state that is unacceptable in this context. The information contained within the expose was directly harmful to the Secret Service and intelligence operations of UCSI and its ability to protect its 8 million citizens. To allow this risk to materialize by hinging on the goodwill of Graviola before sanctions have been imposed on her is an unacceptable risk and one the state simply cannot take in this context. If I can turn to the first point the applicants made on rebuttal, which is that Graviola is not a subject of interest, and that there is seemingly tension between our arguments because her communications were interfered with. However, what the applicant is attempting to do here in this context is suggest again that there was monitoring of Graviola beyond the initial search of the laptop. The search of the laptop occurred on a subject of interest, Dr. Vittoria, and the incidental privacy rights of Graviola were implicated as such. This is specifically contemplated as UNSA allows for the interception of communications. Whom are communications to, if not third parties? The law clearly provides for third-party interferences in this incidental application. And again, the applicants need this status of wiretapping, of other monitoring, to justify this point. And simply put, Your Excellencies, as found by the court, that is not the case, and it cannot be the basis of the applicant's point. If I can be of no further help to the bench, that will rest the submissions for the respondent, and we yield our case.
Thank you, counsel, for your rebuttal.
The judges will now deliberate upon the outcome of the case. Everyone is requested to leave the room and wait outside the court for a few minutes. After their discussion, the judges
They
will
will leave,
invite-
I thought we will.
It's okay. The judges will proceed.
You can stay.
Thank you all very much for your patience. The final bench judges are back in their seats and they're about to give the team's feedback and then announce the result. Judges, over to you.
Thank you very much for the opportunity. I'm going to give an overall feedback on behalf of the bench, and the judges may add anything after that. We found the standard of advocacy extremely high. And I think we have many or almost all complementary factors to indicate to the teams. Your articulation was good, your advocacy was of the required standard. All of you engaged with the facts. You all had knowledge of the law and you used the law. So when you were asked a question, you either referred to the facts or to the law very appropriately, which is what is required in a court. And you obviously all have skills. You have skills to be a trial advocate. And I think that is a compliment not just to you, but to those who you have come with and to your various institutions and the training that you've received. So we were very impressed. The standard, as I said, was very high. And we'll come to this later, but there was very, very little difference between the teams and between the presenters. And we thank you for the industry you have put in and for how seriously you took the task. Thank you.
Okay, I'll go next. I'd like to echo what the President has said. I was very impressed with all the presentations. All of you signposted very well what you were going to say without being, as we say, plonking about it. Sometimes the structure can overwhelm the way that you present, and in no case did that happen here. It was done with ease and fluency. I never lost the thread of what you were saying, even though we were interrupting, and that is a thing that can tend to knock people off course. So I was impressed with the resilience that people showed with the interventions, not all of which, certainly not all of mine, were particularly pertinent, but you coped with that very well. And you kept your heads up. You were still, you were composed. All of these are difficult things. When they're done well, they look easy, but we all know that it takes quite a lot of practice and habituation to get those things done well. So you were all very polished in your presentation, and I agree that it's been very difficult to draw a line between any of you, both as teams and as individuals.
Yes, I think this will probably get quite repetitive in terms of saying these things. I mean, truly superb. You should be incredibly proud of yourselves. I think the ability to respond calmly under pressure and to come back, sometimes to concede points, but also come back with some very detailed arguments, use of case law, and not just European Court of Human Rights case law, which is very much to be commended. And I'm just excellent sort of oral presentation skills, so well done.
No. So I also want to congratulate both teams. Excellent presentations. Being a coach myself, I also want to congratulate coaches for enormous work. I think you have lived with this case for the last half a year. You slept, you were living with it, which you see the results. So I have seen in Strasbourg, and for 2 years before I was 7 years in Constitutional Court of Latvia, I have seen many advocating, and I think you really are excellent. So it's also a pleasure for me as a judge when you see that the parties are well prepared, that they deliver their job, at the best level, that they are engaged in arguments, and that's what you all did. Of course, as in every mood, there are limits what you can do, and I also know we all understand that, and we, of course, assess on the basis of your arguments, because that's a mooting. That's part of it. So, yeah, so congratulations to both teams, and it was, also a pleasure, really an honor for us to judge you.
I'm just going to add that genuinely there was very little to choose from between all of you. You were fantastic. Very clear, calm, confident, fluent, had very good mannerisms, nothing distracting. So really well done, all of you. Congratulations.
Just to acknowledge all the teams who participated. Can you all stand up, please, who participated in all these rounds? And let us give them a round of acknowledgement. I think we recognize your commitment, your hard work, your dedication, and in taking this through right to the end and in coming to the finals. We didn't observe you, but I'm sure as the teams today, there's very little between all of you. In a sense, it's almost unfortunate that we have to have a winner and we just not have the presentations, but it is just the way the world works. And sometimes it can make us stronger, not to get to the final point here, but you get past the final somewhere else. So the fact that you have gotten here, we have immense pride for you, and we recognize your hard work. And we come now to the very difficult task. I think, excuse me, it would have been easier if they asked us to write a judgment. Can I ask the two teams to stand up, please? And their coaches. Can we give them another round of applause? And this is really difficult. The team that won the final competition for just the structure of the argument, and I don't even want to go into it because both sides did excellently in everything, is Team 1.
All of you.
She needs microphone.
Fiona, do you want a microphone?
And I know I keep saying how difficult this task was. It was even more difficult to choose the best odalist in the finals. Because you were also composed, you were distinguished, you were mature. And some of the things they don't really teach you a lot in law school, but you presented as counsel should present. But at the end of the day, the winner is Mr. Staines.
Thank you so much to our very distinguished final bench. And we invite Professor Rachel Murray, the director of the Bonavera Institute, just to say a few words.
Thank you so much. Huge congratulations to the finalists and to the winners. Just immensely amazing work. I'm going to take very little time, and I know there'll be additional thanks here, but I just want to say a thanks to our final bench, Justice Leona Teron, Dr. Mariam Kamil, Judge Arturs Kutz, and Lord Justice Warby, and all of those, some of who I know it in the audience, who've judged the final rounds. There are many of you. If I listed you, I would go on for ages. You're all on the website, but thank you for your time and dedication. People keep saying to me, thank you for the Moot, and I've been saying, I've been the director of the Institute for such a short period of time, I cannot take any credit for this at all. And I know others will thank them, but I just personally want to acknowledge the amazing and truly incredible team for their efficiency and organisation. So the wonderful Nevena, there she is. Camille. Sanya. And then my colleagues at the Institute. So Eliza, Sarah, Rosie, there she is. Morag, Sophie, I can't see, is she around? She's not here. And also Zoe, whose work is often hidden, it's all the finance. And our two amazing RAs, Advait and Justine. Advait's here. And also Naomi, who has been assisting with the team. And just also a thanks to Professor Cato Reagan, who was the previous director, who must take credit for the organisation of this because I have been here for such a little amount of time. So thank you so much for all your super, super hard work. And just finally, Munro Price, who sadly I did not have the opportunity to meet or engage with, but pay respectful tribute to him. So thank you.
May I say a few words?
So we want to take this opportunity as well to thank others who are integrally involved in our Moot Court, not just here in Oxford for the international rounds, but the regional rounds that you all participated in, and I'm sure had the most tremendous time before you got here, and that helped you to prepare for getting here. And first, we want to thank, for the Asia Pacific rounds, Jill Anthony Aquino and Alvil Halcon of the Lyceum of the Philippines University. For the Europe rounds, the University of Paris Cité, Nada Abu Soud. The Americas rounds from the Benjamin N. Cardozo School of Law, Sejong Lee. For the South Asia rounds, from NLU Delhi, Jayot Preet Kaur and Jalak Kakar. From the Middle East rounds, Ain Shams University, Ahmed Khalifa, who is here. And of course, Ola, who we also love so much, Ola Nagy. And the Africa rounds, Sanya Samtani. Great. So, our judges, and for a lot of you, I think you've gotten to the point where you are nauseated with the amount of emails you've gotten from me. But we cannot thank you enough for the time that you've taken, not only to invest in being here to hear the students advocate, but your preparation as well, which was meticulous, which was detailed. And I think, like our final bench judges, you really got into the case so that you could engage with the students at a very deep level. And I'm sure the students are very appreciative of that. So I just want to take the opportunity to thank you all for the time that you've committed to this. We could not do this without you. You are integral to our community, and we look forward to seeing you all, not just here again next year, but in our various regional rounds as well. So thank you so much to our judges. And, you know, I don't like to pick people out, but there are some amongst our judges who just went far beyond the call of duty, not just to assist with judging, but to assist with, you know, the various events that took place around the Moot. There were judges who were helping us to organize things, and I do have to point out very especially Tom, Holly, Abraham, Lautaro, Paolo, and Alexander Willingham as well, who's had to go back to London. But we really do appreciate, you know, all the effort that you gave, all the care and attention that you gave to this Moot. Yes, we really love and appreciate you all. Thank you.
I wonder, could you hear me? Hello?
Oh, I think that's...
Hi, May.
I wonder if I might say a word. Is that all right?
Absolutely.
Thank you. On behalf of my dear departed husband, Monroe Price, who is very much with you in spirit, I want to congratulate you all. This is really heartening and wonderful to hear so many wonderful Mooters who are dealing with complex questions. I'm speaking to you from New York City, by the way, where it's very early in the morning. And it's really heartening to see that you argue these complex questions, cultural, moral, legal questions, and some of you doing it in a second language, which is also formidable, really. And I hope, and as my husband hoped, that you'll be, now that you're part of the Moot court, that you'll keep in touch with one another, because there is a grand network that we were lucky enough to see over the years of Mooters who came back as coaches and then judges themselves. And especially in dispiriting times, it's really quite wonderful and great solace to see so many intelligent, really extraordinary people from so many countries come together to argue these intentionally extremely complex questions. So I thank you so very much, and I know Monroe is with you, and please keep it up, and it's really heartening. Thank you so very much. He died, as many of you may know, last month. Thank you very much.
Thank you so much, May. We are now going to continue with the award ceremony.
All right. Hello, everyone. I'm here to recognize our tireless regional judges. The regional judges, or the regional rounds, would have been impossible without their contribution and effort. And I was actually at the European and Middle East rounds, and I can attest to that because I saw it firsthand. We'd also like to recognize our regional and international memo markers. These are Petr Radoslavlev, Chani Shrivastava, and Juliana Moto. Juliana is also the author of the case. and the bench memo, which was really helpful for all judges, myself included. Oh, and Peter also, sorry, he also was involved in the bench memo. So thank you so much. And I'll hand it back to Nivena.
So I'm just going to once more mention the organizing committee. You have all the names here. And I'm just going to say to Rachel, thank you, Rachel. You did a lot, because just having support of all these people, it's only possibility to make all of this happen. So once again, just a round of applause for everybody. So before we move on, I'm going to call my colleague Rosie so she can talk about all the teams that were here.
Thank you. So congratulations to you all again. What we'd love to do is just invite a round of applause to each of the individual teams. Before we get started, just to let you know, your certificates of participation have been sent to you in your Dropbox folders. So you should have them. If you're here, obviously, please, we ask you to stand when I read your names. I hope I pronounced them correctly, your universities, and we'll give everyone a round of applause. How do I click through? So, Team 102, the University of Belgrade, Serbia. Oh, wrong way. Team 103, the National University of Kiev, Nahola, Ukraine, in Ukraine. Team 105, the Law Society of Ireland. Team 106, the University of Bucharest from Romania. Team 107, Faculty of Law at the University of Ljubljana, Slovenia. Team 108, the University of Vienna from Austria. Team 113, the University of Oxford from the United Kingdom. Team 204, the National Law Institute, University of Bhopal in India. Team 214, the Eastern University from Bangladesh. Thank you. Unfortunately, they couldn't make it to the international rounds, but we still want to acknowledge them, so thank you. Team 221, Nalsar University of Law, Hyderabad, India. Team 224 also unfortunately couldn't make it, but Dunning Law School from Pakistan. Team 232, Gujarat National Law University, India. Team 236, Hidayatullah National Law University, India. Team 401, Brooklyn Law School from the United States. Team 402, the Benjamin N. Cardozo School of Law, United States. Team 403, Universidade de Sao Paulo, Brazil. Team 407, University of Chicago, United States. Team 408, Osgoode Hall Law School, Canada. Team 502, Doha Institute for Graduate Studies, Qatar. Team 504, Ain Shams University, Egypt. Team 507, the Applied Science Private University, Jordan. Team 509, Dar Al Hekma University, Saudi Arabia. Team 510, who also couldn't make it, Cairo University, English section, Egypt. Team 512, the British University in Egypt. Team 702, the University of San Agustin, Philippines. Team 703, Singapore Management University. Team 704, University of the Philippines. Team 705, the University of International Business and Economics, China. Team 706, Lyceum of the Philippines University, College of Law. Team 709, Peking University School of Transnational Law, China. Team 710, Ateneo de Naga University, Philippines. Team 803, University of Fort Hare, South Africa. Team 805 sadly couldn't make it, the Ambrose Ali University, Nigeria. Team 806, who also couldn't make it, the University of Iringa, Tanzania. Team 807, Africa University, Zimbabwe. That's you all. So just to round up, we just want to bring up onto the screen our octo finalists. So we'll just do a group round of applause once again for those of you. Our quarter finalists. Semi-finalists. And to finish, of course, with our two finalists, Team Osgoode Hall School, Law School, Canada, and the University of San Agustin, Philippines. Am I done? I think I'm done. I'm going to hand back to Camille and Sanya. Thank you.
So, as you all can see, there's still some awards left to give. And we are delighted to announce the Memorial Awards. So the runner-up for the best memorials this year is Peking University School of Transnational Law, China. And the best memorials for this year's competition goes to the University of Vienna, Austria. That's great. Yeah.
Am I supposed to be on the
Yes.
picture?
Yes.
Absolutely. I'm supposed to be in the picture. This is fine. I'm up for it.
And then for our top oralists, okay. Okay, and the awards for our top oralists in the preliminary rounds. So we had 98 oralists in all, and I think Judge Theron said it quite well, that there was very little that separated you all, coming down to the finest of margins, sometimes like 0.1 of a score. So very close indeed. But our top 10 oralists, if you're here, we invite you all to come so that we can get a picture with you all. So in 10th place, we have Marco Giorgiorni Edava, University of San Agustin, Philippines. We'll take one all together. Then in 9th place, Lucian Sismar, University of Bucharest. And I think they're the top two get awards, so you have to present those. In 8th place, we have Ada Kojing Xuan of Singapore Management University. In 7th place, we have Aidan Fields of Singapore Management University. Is that right? Oh, I'm sorry. Yes, I'm so sorry, Aidan. University of Chicago. We'll make sure that we correct that for your certificate for sure. And in 6th place, we have Soundarya Diner. Also not Singapore Management University. In 5th place, we have Dari Alexandru Velikovici of the University of Bucharest. In 4th place, we have Eve Cooney of the Law Society of Ireland. In 3rd place, we have James Staines of the Osgoode Hall Law School, Canada. And our best oralist runner-up in the preliminary rounds is Milica Kukaniak of the University of Belgrade. And finally, our best oralist in the preliminary rounds, Alyssa Gillespie Music of Osgoode Hall Law School. Thank you so much.
Many, many congratulations to the winners of all of the awards. It's really wonderful to hear the buzz, and we're all really proud of you. As we kept saying to all of you, the judges said that the quality of oralists was extremely high this time, and you know what? The judges were right. So congratulations to all of you. There are just a couple of final slides, and then we will release you all. There is an award that we give every year, which is the Jonathan Blake Spirit of the Competition Award. And that award essentially honors the members of the Moot community who continue to persevere in the face of adversity, particularly to promote human rights and human rights education through their participation in the Moot. So this is not always related to the scores that they get in the competition or anything. It's largely related to their conduct as part of the competition. And this year, we are awarding it to the University of Bucharest. Congratulations. Nebina, please. We also decided this year that we would announce the dates of next year's competition. We really hope to see you all there. Next year, we hope to have our 20th edition of this competition between the 12th and 16th of April here at Oxford. Please do save the date. We hope to see you all next year as well. Once again, many, many thanks to the final bench for taking time out of your schedule to judge this final round of the competition. It means a lot. I would also just like to ask the finalist teams to stay back here for photos with the final bench before you then go ahead and disperse. But once again, congratulations to everyone, and on behalf of the Price Moot team, and I'm looking here at the organizing team, I'm looking here at my colleague Sarah as well, if there's anything else, Rachel, if there's anything else to add. All right, well, thank you all very much. Safe travels and goodbye.